Okay, so oh. So some of this we'll have dealt with, but I'll just whiz through it again because it's quite easy for this sort of thing to be examined in a question. Okay, so requirements to transfer. When I talked about a gifting, if you want to create a valid gift, you can do it by deed. So you can execute a document as a deed. Otherwise, you need intention to give plus delivery of a chattel or shows in possession. Now, there's some other rules on giving. So your intention has got to be to give immediately. You're not saying, in the future, I will give you this, because that's not legally enforceable unless it's in a deed. Now, when you deliver, you may have something that is of a reasonable size that you can just hand it over, but you can actually have constructive delivery. So there is a case, it's Rawlinson and Mort, where a church organ was gifted, and it was gifted simply by somebody putting their hands on it saying, I'm giving this to you. So you have to have some sort of act showing that there is a release of dominion and a transfer of dominion over to the other person. That's what you're looking for. So Lock and Heath was a case where there was, I think, a table and chairs, and one chair was handed over. So you can do things that constructively enable delivery. Also, delivery can become before and after the words are used. So I'll just quickly go through the facts of this case, Thomas and Times book, because it's historically, I think it's quite interesting, and it shows the point. So this is about Dylan Thomas, the Welsh playwright, and he wrote a famous play, it's just sort of comical in a way, called Under Milkwood. And the manuscript of it, actually I think it was originally transmitted as a radio play, but it's been done on stage now. So Dylan Thomas was a famous drunkard. And he was married, and I think he had 2 children with his wife, but he died relatively young. But before he died, and after Under Milkwood had been produced, he told one of the BBC producers that had put on the play that this producer could have the manuscript if he could find it. And he said, I've left it in a pub somewhere in Soho in London, where there's a pub on every corner. In fact, there are a number of sort of places that Dylan Thomas thought it was, and he said, well, it could be here, and it could be there, and it could be there. So, and his words were, if you can find it, you can keep it. So it was found in a pub in Soho, and then Dylan Thomas died, and his wife, Caitlin, argued that that manuscript, the producer had it, but it hadn't been validly gifted by her husband, by Dylan, to the BBC producer. And the argument was because delivery had happened, there wasn't adequate delivery. Just saying, if you can find it, you can have it, is that enough? So the courts actually felt that it was a valid gift. Because the possession, the donee, the person who received it, actually did find it. Yeah. So delivery can become before or after the words of giving, but you need both. Unless you've got a deed of gift, you need both to create a valid gift. Now, I won't go through all of these. I've actually set some of the materials out in the workshop, but although, like money and chattels are easy, transferring legal title is relatively easy, there are a number of things where transferring of legal title is dealt with in statute. So there are general clauses about shows as an action under the Property Law Act, and the old Act or the new Act, depending on the timing of the transaction. Shares are covered in the Companies Act. For bills and things, you've got the Bills of Exchange Act, Cheques Act, all sorts of legislation that cover all sorts of different things. Now, so what I've said to you is you normally have to, with your gift, transfer legal title, and with your trust, transfer legal title to the trustees. But there are a number of exceptions that can apply, where although legal title hasn't been transferred, equity will recognise that equitable title has been transferred. Okay? So we'll just go through some of these. And some I won't go through. I'll just tell you, Donatus Mortis Causa is, you might remember these from law school, it's the dying declaration, where you say to somebody, in contemplation of imminent death, so you think you're about to die, and you say, you can have the car. So there are regulations as to when, even though you might have dealt with the car under your will, that gift will be recognised under the principles of Donatius Mortis Causa. So we won't go into those. But the main ways in which gifts or trusts can be corrected are under principles in Rerose and Pennington and Wayne. So what you've got to think about this is as being equity recognising that equitable title has passed, even though title at common law has not passed. So Rerose is basically a case where a settlor had executed a documentation for transfer of certain shares, but the transaction, and so it signed the transfer basically, and given the share certificates to the company, but for some reason the share transfer wasn't registered. It was delayed for a particular period for about 3 months. And then later the donor died, but for various reasons they had to determine some tax that was durable, and so the date at which this asset was transferred became relevant, and they had to work out, well, was the asset transferred actually in equity actually at the date of registration, or could you argue that the gift was made at an earlier date and that equity would recognise the gift at an earlier date? If you could recognise the gift as being complete in equity on the earlier date, the tax wasn't payable. It's one of those sorts of cases. So, basically, the equity came up with the solution. So the principle is that a transfer can be considered to be complete in equity, even if it isn't complete at common law, when the transferor has done everything in his power or her power to transfer the legal title to the transferee. So where you have a situation like the one in that Galvin and Scones case, where if the uncle had given both the memorandum of transfer and the certificate of title to his nephew and then died, equity would treat the gift as complete because the nephew had all the documentation needed to make the registration, and the transferor, the uncle, had put himself in a position where he could not recall the gift, could not change his mind. So this principle from Rerose operates where the transferor has done everything in his power to transfer legal title to the transferee and is in a position where he cannot change his mind or her mind. Okay. And an example of this, a similar sort of example is this case of Maskell and Maskell. That was a case where a father was the registered proprietor of some land, and he handed all the documentation for transfer of legal title to land to his son. Now, before the transfer took place, so before registration of the change in ownership took place, the father and the son fell out, and the father demanded that the son give him back the documentation. He said, "You're not getting land, give me back the documents." And the son refused. And he said, "No, this gift is complete in equity. Equity already recognises me as the owner, even though I haven't actually registered the documents to show the transfer of legal title." And the courts looked at the matter and they said, "Well, who held it?" And they said, "Well, under Rerose, or the similar sort of principle, the father has no legal right to demand those documents back from his son. He's given them over, and therefore he's put himself in a position where he cannot change his mind, and equity would treat the transfer of equitable title as being complete and treat the son as the owner of the asset, yeah? Even though title hadn't been registered in the Land Transfer Office." So what you're looking for when you're looking to apply Rerose is a situation where the transferor has completed all the documentation, but for some reason legal title hasn't been transferred, but they must be in a position where they can't change their mind. And there's, for certain, I just won't, that's for certain shows as an action, the rule in Re Rose is put in statutory form in the Property Law Act. Now, even that rule, the Re Rose rule, doesn't look to remedy every situation in which there might be a problem. So, relatively recently, the English courts came across this case, or this case arose in the English courts called Pennington and Wayne, and that extends the principle. So if you're attempting to give a gift, you haven't transferred legal title, there is an ability for equity to treat the transfer as complete anyway, where it is unconscionable for the donor to recall the gift. Okay, so I'll just take you through the facts of that case. There was a woman whose name was Ada Crampton. She owned shares in a company called Crampton Brothers. She was getting older and she decided that she wanted the next generation to take over. And she had a nephew who she was very fond of called Harold. So she wanted to transfer her shares to Harold. So she held 400 shares. She wanted Harold to be the shareholder, and she also wanted Harold to be the director of the company, to get involved in running the company. Now, under the company's Articles of Association, what we would call the Constitution, Harold could only be a director if he was also a shareholder. So Ada told Harold, I'm giving you my shares, and I want you to be a director, and she got him to sign consent forms to act as a director. And those were filed. And in fact, Harold believed that he was validly appointed as a director of the company and started acting as a director. Now, in relation to the transfer of the legal title to the shares, what Auntie Ada did was she told Mr. Pennington, who was the company's auditor, to arrange the transfer of shares. So she signed what she needed to at the time under the relevant English legislation. She signed a share transfer form and gave it to Mr. Pennington. And now the share certificates, her share certificates, were already in the hands of the company. The company already had those. So all she was doing was signing the share transfer, and she gave it to Mr. Pennington. And he promised that he would look after things and take care of the transfer. And in fact, Harold went to him and said, is there anything else I need to do to arrange the transfer of these shares? And Mr. Pennington said, no, don't worry, I'll look after it. And he didn't. Yeah. Now, Ada, thinking that she had validly given these shares to Harold, didn't leave Harold assets under her will. She left it to other people. She thought, I've given this, in my lifetime, I've already given away these shares to Harold. Lo and behold, she dies. And then what they find, the executor finds, is that she's still a registered owner of the shares. So the argument is, well, can we fix this by applying the Re Rose principle? Has she done everything she can, to complete the transaction? Well, she didn't. It didn't comply with Re Rose, and the reason why is because what she did was she handed the share transfer form not to Harold. If she had handed it to Harold, she'd have been fine. She handed it to her agent, Mr. Pennington. Yeah. And so because he was her agent, she retained the ability to recall the gift, to change her mind. Now, the fact that she didn't is irrelevant. The argument in equity is, has she done enough to put it beyond her ability, up to the point of her death, to change her mind? And she didn't. So then you were left with this very unfair situation that Harold missed out under the will, believing that, and Ada died believing she had benefited her beloved nephew, and she hadn't. So the case went to the English Court of Appeal, and the English Court of Appeal said, look, in all the circumstances in this case, we simply think it would be unconscionable to not to recognise that Harold is now the owner in equity of these shares, and we will treat the transfer as complete in equity, even though legal title hasn't been transferred. Now, the trouble with using a word like unconscionable in law is that everybody has a different idea of what is unconscionable. So you're looking to the conscience of the particular judge deciding the case. Now, if we go back into history, one of the big faults, one of the things that problems that equity had when it was first starting out, and it was criticised for, was being not having principles by which it could be judged, doing things in good conscience. And there's a joke, sort of. It's not very terribly funny now, but it came out in sort of the 1700s, which said, you know, equity's like the Chancellor's foot. You look to the Chancellor's foot. So every Chancellor will have a different size foot. So every Chancellor will have a different conscience. And so if you say things have to be decided in good conscience, you're not taking a principled approach. And that's problematic because under our legal system, we look to treat everybody alike. We want like cases to be decided alike, and also we want justice done in a particular case. To get both, you need to have principles that are going to be applied in the same way by different people. That's the idea of it, so that you get like cases decided alike. If you just rely on conscience, then you risk one judge thinking that something's in good conscience when another doesn't. You get quite varied decision making. So this decision, Pennington and Wade, has been criticised because who knows what it means to be unconscionable. And we use that term in a number of different ways in equity. So in relation to this case, how would you use it? Well, the only way, what you would do if you wanted to rely on this case is try and match the facts that already exist. Say, well, look, these were the things that had happened. Ada thought she'd given the shares properly. She was assured by Pennington she didn't have to do anything more. Harold was assured by Pennington that nothing more needed to be done. She died believing that she had gifted these assets to her nephew. So comparing facts is all you can really do. So, when you're dealing with a question, you know, in an exam about this, there is a technique to arguing them, and we'll look through the we'll look through the facts. But what you'd normally do is look at the transaction, and so you might, you know, if it's a trust, you'd have to see whether the three certainties are there. Then you'd see if it's properly constituted. If it isn't properly constituted, there's been no transfer of legal title in the way that it should be done. The first thing that you would do is to say Milroy and Lord applies. Equity will not assist a volunteer. Equity will not perfect an imperfect gift. Equity will not treat a failed gift or a failed trust as a transfer as a self-declaration. But then we do have these exceptions. So you'd say, well, that's a position unless you come within an exception. So first you would look at, does re rose work? Because that's well, you know, recognised in case law. And if that works, fine. But if it doesn't, and the normal reason it would fail is because the donor or the person given or the settlor has not has left relevant documents or powers with an agent of their own agent, so they can recall the gift. If you're in that situation, you would rely on Pennington and Wayne to say, well, is this unconscionable? And then what you have to do is pick from the facts arguments that you could rely on to say that something is unconscionable. Now there is a third exception, which actually, this case has been applied in New Zealand by Justice Heath in the Levin decision. But I'll just go through it with you because it just shows you how contorted the law sometimes will be in order to perfect gifts. And this is the case that I mentioned about Mr. TCP, Mr. Choitram, I think his name was Thakurda Choitram Pagarani. So he was, as I said, very wealthy, devout Hindu. He'd made his money in supermarkets. They're still there. Choitrams, full of goodness. That's what you see if you go to Sierra Leone. So he had married a wife in India, and he had had 6 children with her. And then he'd moved to Sierra Leone, where he met an Englishwoman, and he had 8 children with her, including 3 sons. He was very generous to both his families, but also to charitable institutions. Basically, what he intended to do was he took care of all, his 2 families, and what he wanted to do was actually make a significant charitable contribution on his death. So he gave away what he thought was most of his wealth, and then he wanted to leave the rest of it to these charities. And the way he wanted to do it was basically to set up a foundation that would serve as an umbrella organisation for this charitable giving. Now, as he got towards the end of his life, actually he died of cancer, but he got cancer. It was, cancer was discovered, and he came to London to die. So he was in a home in London, and he arranged, some of his sons were with him, and he wanted to arrange a formal ceremony where these foundations would be set up, and he would be seen to be giving these assets to these various charities. And the assets were mainly cash deposits, so they were shows as an action. So a formal ceremony was arranged, I think he might have been bedridden by this stage, where he was supposed to sign trust deeds and hand the wealth over. Now, the law firm that was acting for him was a very good law firm, and they actually tried to get him to sign all the documentation beforehand and just have a ceremony, But he refused to sign a lot of documentation. He just said, "I don't need to do it. Didn't want to think about signing things. So I'm not doing it. I'm just going to have the ceremony." So he had the formal ceremony. There was the High Commissioner. I think the Indian High Commissioner was there, and various dignitaries, and his children were around them. And he made this declaration where he said, "I give to the foundation everything that I own. I'm giving away everything I own." Now, and then he died. But although he had signed some trust documentation, what he hadn't done was signed all the documentation necessary to transfer assets into the trust. And he'd been refusing to do it because he just, I don't know, it's not explained why, but he just refused. He just said, "I don't need to. I'm not doing it, don't need to." So then, with him dead, it was down to the lawyers to work out, well, what did he still own? Because that would go to his family, and what actually had been given into the trust. So you can see, I think when you read this case, you can see that this case went up to the Privy Council. The Privy Council is leaning towards trying to recognise this charitable giving because they know the family's already been looked after. And this obviously there was a significant amount of wealth that was going to go in these charities, and they wanted them basically to take effect. So what they have done, I think, it's quite criticised, this decision, is manipulated the rules. So they've taken the words "I give to the foundation." Now that would indicate that he was making a gift, so which you'd have to have intention to give plus transfer of legal title, to mean "I give to the trustees of the trust, this particular, to be held by them on these certain trusts." So basically, what they were doing was taking words of gift and treating them in a way as words of trust, which is not what you're supposed to do. And they determined the justification they gave for recognising in equity that these assets were held in trust, even though legal title hadn't been transferred, was because TCP, Mr. Pagurani himself, was intended to be one of the trustees and was one of the trustees under some of the documentation. So they said that when he used the words "I give to the trust," that was like a self-declaration. As far as he was concerned, he no longer owned his assets in equity, they were trust assets. So they said that is enough to recognise. So they said, although he was using words that were like a transfer and trust, because he was one of the trustees, they effectively treated it like a self-declaration, and they said that's enough. So once the self-declaration is made and he himself is treated as holding these assets in trust, then they are treated as trust assets, and all that needs to be done is legal title needs to be transferred into the names of the other trustees, because they didn't have to transfer legal title into his name because he was already the absolute owner. So it's one of these things that almost falls between a gift, a transfer on trust where you transfer to people who aren't trustees, and a self-declaration. The mere fact that he was one of the trustees enabled the court to treat it as a self-declaration, say these are trust assets, even though they're not held in the names of all the other trustees. It's enough that he himself has treated them as such. So it sort of falls between the stalls of the case law we've got. So it didn't matter that property only vested in one trustee, Mr. Pagarani himself, as his conscience was affected. And the court said, well, he couldn't recall the gift. He had made the declaration. He couldn't recall it, and therefore they'd treat it as being valid. And yeah, but it's a bit of an awkward case. Also, we've got rules of equitable estoppel, where if somebody's, with words of an imperfect gift is created, and so somebody says, I'm going to give you this, and then the donee, the recipient, intended recipient, undertakes acts to his or her detriment, believing that the gift is perfect or will be made, then, and the donor, the giver acquiesces, allows them to act to their detriment, then equity will stop the donor from denying the gift. And you see some of these cases, don't you, sometimes with old people where they say, if you look after me till I die, you can have my house. So it's that type of thing. So although we start off by saying that equity won't perfect an imperfect gift, in fact, we've got a number of exceptions to that rule. The Ree-Rose one, Pennington and Wayne, Choitram or estoppel can come into play. And as I say, there are other ones that sort of operate along the way. And I'll just go through the facts of that. That Thomas and Thomas is a case where a husband said that he would gift a property to a house to his wife. She made mortgage payments on it. She wasn't the legal owner. She made mortgage payments and other outgoings, and so equity arose in her favour. She had acted to her detriment. Her husband knew that she was doing that and allowed her to do it. And so equity said, you can't deny the gift now. You said you'd do it. She's acted to her detriment. You've got to complete the gift by conveying the house to your wife. Okay, so just what I said, when you're doing a question, start with the main principles for Milroy, know the ways to transfer property, know the exceptions, and also know that if a trust is improperly constituted, if it doesn't have any property in it, it fails. Okay. Shall we, what I can do is go now and do formalities, and then we can spend some time just doing those questions. That's right? Yeah. I'm actually going through this material reasonably swiftly. So I'll just get my... next slides up. So now we're just going to move on and have a look at formalities. So basically, when we talk about formalities in a technical legal sense, what we mean are statutory requirements for some sort of writing for certain transactions. Okay? So we know that dispositions that are to take effect on death, wills, need to be in a particular form of, normally they have to be signed in a particular way under the Wills Act. So you've got controls on recognition of wills, and also on certain types of assets that are held in lifetime trusts, basically where the trust property or subject matter includes land. And then we also have some controls on dispositions of equitable interests relating to land. Now, I'm just going to say now, New Zealand, under that Property Law Act in 2007, has changed some of its rules. It's not always clear to me why New Zealand did that. So we had certain rules that were in place for about 400 years that have worked quite well, but we actually have changed them. So you just have to be aware, you've got to understand that if you're looking at something before the Property Law Act takes into effect, the earlier laws will apply, and after 2007, as I say, you've got different rules that apply, but we'll go through them. Okay, so why would Parliament intervene and require that certain transactions need to be done in writing? Well, the main thing is to prevent fraud. So to protect people where allegations are made of of secret oral transactions. And that was particularly the case, some of these things, well, it arose actually very early, but where people were basically defrauded out of them by saying, well, you said you'd give it to me. Or whether they did say they'd give it, but they were, manipulated, is the idea of it. So the first thing is to prevent fraud, and the second reason is so that trustees know to whom they owe their obligations. And some of these rules are discussed in this very famous case, Vandervelde and the IRC. I think that is actually Vandervelde, who was another very wealthy guy. I think he made his money through manufacturing ball bearings. So it's an important piece of legislation. So I've just stuck up there Section 11 of the Wills Act. This is an example of formalities. It says a will must be in writing and a will must be signed and witnessed as described in subsections 3 and 4 below. So there you get what needs to be done. The will maker must sign the document, acknowledge that a person directed by the will maker signed the document in the will maker's presence, and at least 2 witnesses must, do whatever they have to do, sign as well. So you have this description in statute of a type of a formality, not quite a ceremony, but a procedure has got to take place for there to be a valid will. Having said that, the courts are more willing nowadays, and particularly under this Act, to recognise informal wills, but that's the ceremony. Now, there are 2 provisions under the Property Law Act that deal with what is required in terms of formalities in relation to equitable interests. Okay, and they're slightly different. So the first thing we want to look at is what formalities will be required when you are creating a trust for the first time. Okay? So you've got a settlor who's absolute owner. They split absolute ownership into legal title and beneficial title. Okay? So where you've got that, the provision that is relevant is Section 25, subsection 2 of the Property Law Act. And what that says is a trust must be created in writing and signed by the settlor if it relates to land and is to take effect in the lifetime of the settlor. So know that we're not dealing with a will, we're dealing with a trust, creation of a trust, where an asset is being put into trust for the first time. It's to take effect in the settlor's lifetime, and it relates to land. Yep. And that rule comes into play from the 1st of January 2008. That's what you need to do. So if a trust, lifetime trust or inter vivos trust is created and it relates to land, then the declaration, the trust declaration itself, must be in writing and only the settlor can sign. Okay? Now, that operates for express trusts, but it specifically does not operate for resulting in constructive trusts. Particularly, because we use constructive trusts in New Zealand as a form of remedy, a remedial constructive trust. So they don't need to be in writing. Not quite sure how long I've gone back. So we did operate a completely different regime before that, and it was a regime that was actually unchanged since the Statute of Frauds in 1677. So there we have in the far corner, Charles II, Catherine of Braganza, his wife, who's said to have introduced tea to England. And I think her dowry was the port of Bombay, or Mumbai, I suppose it is now. And that's his famously his mistress, Nell Gwyn. So from 1677, our law was unchanged until 2007. And it was a completely different regime that operated. In which, anyway, I won't go into the details of the previous regime because it's just confusing. So what this means in our latest regime from 2007 is that if the trust asset doesn't relate to land, then it can be oral. Yeah? So if you are giving away personalty, choses in possession, and other forms of personalty, there are no formalities. You can do it orally. So I could declare a trust of jewellery, or my dog, or shows as an action, shares I hold. I can do it because they don't relate to land. Quite what the term relate to land means, I mean, certainly it would mean me declaring a trust over a land of which I'm the registered proprietor. Yeah. Beyond that, you might be able to argue that it's got an extended meaning. But where property comprises chattels or shows as an action, then the declaration can be oral. Yeah. And there's a famous, I put this case in, do you know Belton? I put this in because it's a New Zealand example of it because it involves sheep. And it's about a declaration of trust over a flock of sheep. So in this case, a father bought some sheep and he raised them and he sold them off. But the particular sheep he bought them and he said they were held on trust for his son. And he started trading in these sheep, basically. And he kept the money, the profit that he made from it, he kept in a separate bank account. Yeah. And he also kept the sheep it was very, separate from his own flock. So he said, those are my son's flock, there's mine, separate thing. Now, there were some significant trading profits from what he had done. And the issue arose as to whether he was liable for tax in relation to that. And if so, from what date. He was saying, I'm not liable for tax because I don't own the asset. The asset is held in trust for my son. I'm only the trustee. Tax, the revenue, what had happened is he'd actually traded, he'd set up the trust orally for a number of years and then later it had been documented. So the revenue was saying the trust only took place from the date of the documentation, and he was saying, no, that was just recognising a trust that had already been in place for a number of years, and during those years I'd actually made a profit. So that I shouldn't be taxed on that profit because it didn't belong to me. I'm not a beneficiary of, it was for the trust, not me. And there was about, I think he started trading in 1948 and the documentation was put in place 9 years later in 1957. Anyway, so the matter went to court and the court looked at what had happened and the court said, well, no, this is a trust that doesn't need to comply with formalities according to the regime at the time, and it is a valid trust that, even though it's been created orally. So they took the trust as being created in 1948 when he first segregated the sheep from his own flock, yeah? And obviously, made his declaration of trust. So that's a relatively simple rule.
The other one up there is intellectual property. It's got to be in writing as well.
Yeah, I haven't done all of yeah. I can't. Yeah. In this course, we can't cover all of them.
What's with cars these days? Because cars no longer have.
Well, they're
ownership papers, do they?
No, I actually. Do you know what? I haven't checked. I don't know. There must be an electronic registry. Do you have? What did I do? I don't know.
Vehicles don't have ownership papers, so it's just.
No, but there must be a.
It's an
electronic registry. So there'll be with all of these things.
Anybody can change.
That's right.
Can they just go on?
Yeah, you can just get online.
And
I can get online and change the registration of your car to me.
Can you really? Gosh,
Absolutely.
that's a bit of a flaw.
Anybody can get online and change.
And then, what are the rules for correcting fraud on that? I mean,
I don't know exactly.
I don't know.
Yeah, I mean, this one.
Yeah, there is quite a bit of writing too on, on electronic fraud on land registries. It's become a popular sort of topic for a number, yeah. Anyway, last rule that resulting laws don't need to be in writing. Okay. So there are certain exceptions. We won't go through them all. But although we have rules that say that sometimes, you know, the trust should be created in writing, there are exceptions to it. And so this is a statute that says there's got to be writing. Well, Equity has a maxim that they won't allow a statute to be used as a fraud. So if somebody's trying to rely on the statute to deny that there's a trust, and they're doing it and saying there's no trust, and what they're doing is fraudulent, but their reliance on the statute helps them to perpetrate the fraud, then Equity will say, we'll recognise the trust even though it's not in writing. Now, probably we would say that's a constructive trust. So there's a famous case. It does come up time to time in New Zealand, but the famous case is Rochefoucauld and Boustead. And that is a case where there was a woman, a comtesse, who owned some land at the time in what was called Ceylon. So she had a tea farm. And it was subject to a mortgage, and she, I believe, had quite an enjoyable lifestyle. So she spent a lot of money. She got herself into financial difficulty, and the mortgagee wanted to sell the property. She was keen to sort of try and hold on to it if she could. So she arranged for a friend of hers, Mr. Boustead, and she got basically. It was arranged so that the mortgagee would sell the asset to Mr. Boustead, and he would hold it on trust for her. Yes, that was the idea. In fact, what he did was when he got title to this plantation, which he got, you know, at an undervalue, he mortgaged it himself, and without her consent, without her ever knowing anything about it. And when she found out, she went to court and said, hang on a minute, he can't do that. He doesn't own that property, absolutely. He holds it on trust for me. He turned around and then said, no trust, it's land. There's no signed writing, no formalities, invalid trust. So the court said, so he's relying on the statute to deny this agreement that he had entered into with her, that the tea plantation in Ceylon would be bought by him, but only as a trustee for her. Anyway, so the court basically recognised that and said, no, you can't rely on the statute because it just allows you to, you know, you're using it to perpetrate a fraud. We will recognise you only as having the interest as the trustee, and the equitable interest as being, you know, held by the comtesse. Yeah? So, and probably you would explain that case as just sort of recognising that there was a constructive trust interest for her. But in any event, you know, it is discussed sometimes as being part of this maxim that Equity will not allow a statute to be used as an instrument of fraud. And actually, this latest case, Crampton and Crampton, is quite interesting because it involves it's a very strange case involving some land in Rotorua. And the Court of Appeal goes through a number of ways which in Equity the solution could have been fixed, and one of them was reliance on the maxim. But I'll just quickly go through the facts with you because it is quite an interesting one. So this was a case where it was basically a dispute between a brother and a sister. And the brother lived overseas, and the sister and her husband at the time, who was a lawyer, lived in Rotorua. The brother, I think, initially sent back some money to the sister, and the agreement was that she would buy some land in Rotorua, and it would be held. It was basically she would undertake the transaction, but effectively the agreement was that she was going to hold it on trust for him. I think it was all registered. I think there was wasn't sort of clear who was going to be the registered owner initially, but anyway, she ended up being the registered owner of it, effectively. That property was sold, and some money was paid back to the brother, but then some appears to have just been kept by the sister and nothing much is said about it. So that's in the background. And then the brother sent over more money, and some property, some land was bought in the same street in Rotorua. Again, the idea was that the property, I think the brother believed that the property was going to be his at this stage, but instead the sister it was transferred into her name. And I think, in fact, what happened was that she started building properties on it, and the brother didn't know anything about it. And then one of his children came over to visit and walked down the street and said, there are townhouses on, the house is being built on this section. The brother-in-law during the time sort of died, and then the dispute really arose as to who owned these properties. Were they, was it the brothers or did they belong to the sister? And what is really weird about this case is that the sister defended it, and it went through to trial, and then she offered no evidence in defence, which I find is bizarre. It's just, so I don't know why that happened. Anyway, but so there are a number of ways in equity that you could solve that problem. So first of all, you could say that was there a presumed resulting trust? Or, what was going on here? If the sister was saying this was a gift to her and that she owned it, and the brother was saying no, it wasn't. You were supposed to be doing this for me. You might be able to resolve it through resulting trust principles. But anyway, it also could be dealt with under, the maximum equity will not allow a statute to be used as an instrument of fraud. Anyway, if you feel like it, if you get time, read it, but it's just one of those strange cases that come along. Okay, so just to summarise, formalities when you're creating a trust. For inter vivos trusts, you need to have your document in signed writing if it relates to land. And just remember there are different rules that apply pre-1st of January 2008.
So what needs to be in writing, the trust or the transfer of property to the trust?
So if you, we'll go back, let's go back, actually I'll end it. We'll go back to the section, because you, I'm not sure what it says. A trust must be created in signed writing. So basically the old rule was that the trust could be created even though it was oral and that it was unenforceable. That was the old rule. So you could create it, I could declare a trust that relates to land.
Yep.
Yeah, this is under the old rules. I could say, my house is in trust for you. And then, so that would be treated as a valid trust but unenforceable. But if some signed writing came into effect later that proved that the house was in trust, so I wrote you a letter and say, do you remember that I declared that trust to you? Hope you're enjoying the house. Love, Auntie Helen. Yeah? If I had that thing, that was evidence in writing of the trust, and from that point, the trust became enforceable. Yeah? That was the old rule. But now we've changed it altogether. We say that for the trust to actually come into existence, to be created, a trust must be created in writing where it relates to land.
Okay, but there is a common practice where a trust is set up with a gift of $10.
Yes.
Okay, so in that case, the trust is created.
Yes.
It doesn't relate to the land
Nope.
because you've got a $10 settlement. So
Yes.
the trust exists.
Yes. And then you transfer
And
in.
then you transfer the house in.
Yep, that's okay.
So
Yeah.
at that point, it is the house transfer that needs to be in writing.
Well, that's separate. The house transfer needs to be in writing under the land transfer.
And transfer, yes,
Yeah.
for it to be transferred in.
Yeah.
So you've got to convey the title in writing.
Yeah.
The trust in that case already exists because
Yeah.
it was set up with $10.
Yeah. Yeah. Yeah.
That's right.
But if you're setting up a trust for the first time,
For the first time.
and putting it in,
Land
yeah.
at the point.
Yes, yeah, yeah. No, it's very common. It's like shelf companies, isn't it? It's the same sort of thing.
Yeah.
But the only problem I have, and I've had a number of people in New Zealand talk to me about this, saying, trusts are set up as $10 trusts, but there's never any, often there's no evidence that $10 is ever paid. Now, if that's the case,
It's a debt.
oh, it could be if it says that.
It's a debt.
Well, you might argue that, but then, yeah, I don't know. If the first time the trust is created. I don't know that would, I don't know. Anyway, the best thing would be just staple your receipt or your $10 $10 note to the trustee.
$10.
Yeah. So now just remember the first time the trust comes into fruition, if it's unless you're doing it using that sort of shelf trust, then it's got to be in signed writing. Okay.
But most trusts are done by deed these days anyway, aren't they?
Well, they are. That's right. They are. Except that you get these informal, and actually you get some sort of, there are some really poorly drafted trust deeds around. So you get very odd things that come up from time to time. Like this, these trusts, in fact, some of the step lawyers, when I found out about them, it was when they were trying to fix things up, where trusts were people believed they had trusts, but actually they didn't have a trust. They just had something that purported to give them, make them a trustee of an interest of which they were the only beneficiary, which is not a trust. Yeah, so you do get all sorts of things that come up.
I spend a lot of time resettling, trying to fix
Yes.
trusts.
Yeah, particularly some of the old trusts. I mean, John Brown will come in and talk to you about that, about some of the old forms of trust that you come across that create problems now. So they're still live, and they're just they've created in the 1970s or something, and they've got, because quite often they don't have very good resettlement powers in them. Yeah, so there are all sorts of problems. So he'll come and talk to you about some of those things that you get in practice. Yeah. Okay. Now let's just turn that down, off, and have a look at. And I'm happy to be guided by you as to what we do. Perhaps I'll tell you what we might do first of all, just because we've got an hour, and I want to make sure that you are comfortable in terms of looking at the way things might be examined. So if you have a look at that, I think I put it up there as workshop 5. Have I got it up there? No. Not sure what number it is. The one that deals with, can a settlor make a valid trust of the following? 5 of my 8 paintings. Yeah, we'll just quickly whiz through that. I'll tell you the type of thing, if I have a question like that, the sort of thing I would expect you to write. Once I find my bits of paper. Oh, sorry, it's going to take me a minute to make sure what I've done with it. Read through it and I'll just try and find what I'm looking for. You right to look at the first? Should we have a look at that? Or do you want a bit more time? I don't mind. Okay, so if I put something down here, can a settlor create a valid trust of the following? 5 of my 8 paintings by Ralph Hotary for Alice. When you're looking at a question, and in this sort of area, what you've got to know is normally there are 3 things you need to get right. You've got to make sure that the 3 certainties are covered. So you've got to pick out what is the problem that is being examined in this question. So first, 3 certainties, and if so, which certainty? Because it might be one or it might be any of them. Next, you've got to say, are there any constitution problems and can we fix them using Ree Rose or Pennington and Wayne? And also, are there any formalities that need to be dealt with? And if there's a problem with any one of those things, the trust will fail. So you might have no trouble with 3 certainties, no trouble with constitution, but you've got a trust that relates to land and it's not in writing. Okay, so any one of them can cause the trust to fail. So in this first question, can a settlor make a valid trust of the following? 5 of my 8 paintings by Ralph Hotary for Alice. What I'm looking for there is a discussion of the 3 certainties. Yeah. Now, if you look at it, we need certainty of intention. There appears to be no problem because it's saying, can you create a valid trust of this? Doesn't seem to be any problem with the object of the trust because that's Alice. So the problem here is with subject matter. Yeah? And so what I would expect you to do is describe to me, pick out the problem, and saying this is subject matter and the problem is, here we have a shows in possession. And remember the case law we looked at today? Re London Wine. So I'd expect you to say the problem is knowing which 5 of the 8 paintings are intended to be held in trust. So Re London Wine, it was held there was no valid trust of some bottles of wine in a warehouse because the bottles subject to the trust had not been segregated or identified. You couldn't identify them from the general stock. Now that actually is similar to what happened in Goldcorp. There was no trust in respect of gold bullion because it hadn't been identified, and also it was unascertained goods. Now, depending on the length of the question I ask you, like 5 marks or 10 marks, if you have 10 marks, really think about, you've got to be logical in an exam question. If it's 10 marks, then there's normally going to be 10 things I want to put, not, roughly there's going to be more. So if it's a bigger question, I'm saying, can you do this? What you would also do is talk about Hunter and Moss. Say, well, look, it's a general rule of equity that you've got to identify your trust asset properly. We have this rule that operates with choses in possession, but it has been modified in relation to choses in possession, provided they were all identical. And then you could discuss the Hunter and Moss decisions. You could also refer to Re-Harvard Securities, which is Neuberger's decision that we talked about. So, so you identify the problem, and then you just simply apply the legal principle to it. So here, can you create a valid trust of 5 of my Ralph Hotary paintings? No, you can't. These are tangible assets. They're all likely to be different. One might be worth $50 and the other might be worth $50,000 or $500,000. So the trust is likely to be invalid because the trustee wouldn't know which of the paintings they were actually trustee for. And you could also go on to explain, to create a valid trust, it could be as simple as saying the assets subject to the trust are the ones with the red, dot on them, or that are labelled. So it's, So in the second question, 95% of my 1,000 shares in Fletcher Building for Bruce. It's the same sort of thing, but here I'd be looking for you to discuss Hunter and Moss. Now, normally in a question, just out of exam technique, you don't have to reproduce legal argument in full. So if you discussed Hunter and Moss in your first question, you don't have to recite it all again. Don't waste your time reciting. You can do things like saying, if you've set out the legal principle, this is the same as Hunter and Moss, and then you just apply the principle to it. So you can be rational in the way that you discuss your answers. So in this one, can you create a trust of 95% of my 1,000 shares, provided that those shares, those 1,000 shares in Fletcher Building, are all of the same class, that is, carry the same rights, so they're all of the same value and they're all identical, then you can rely on Hunter and Moss. As creating a valid trust. Is that okay? Okay, so just rolling on to 2. Charlie, who has just died, made a will containing the following provisions: 100,000 to Julian and Robert, in whom I repose complete confidence in the knowledge that they will benefit the employees of Smart & Co lawyers and attorneys. So what you're looking for there, again, is you've got issues of, you've got to go through your 3 certainties. Okay, so the first thing is that, do we know what the subject matter of this possible trust might be? Yes, that's quite clear. We know that the trust fund will be 100,000 if there's a valid trust. What about, well, we'll leave it there for the moment. So we know that we might have no problem with subject matter. We would have a problem if this was something other than a discretionary trust, because we might not know how much each beneficiary is going to get. Okay. But we won't worry about that for the moment. So 100,000 to Julian and Robert, and then you say, well, what's the next problem? Do we actually know that what this person is doing and saying these words, do we know that they are actually intending a trust? Okay, so the test for certainty of intention, you can look at Knight and Knight or Thexton. It's got to be a manifestation of an intention to create a trust. And we look for imperative words, mandatory words. So here, you've got the words, in whom I repose complete confidence. Now, if you look at just those words, they look precatory, don't they? Confidence, that means belief. Yeah. That's a bit wishy-washy. But then you've got the words, in the knowledge that they will benefit, that they benefit. So that looks more mandatory or imperative, doesn't it? They will do it. Okay? But, there is no answer actually in this question. And I'm happy for you to argue both ways. So first of all, you could say, well, the words in whom I compose complete confidence, that's like re Adams and Kensington Vestry in full confidence. Complete confidence, full confidence, it's the same. So you could have a look at re Adams and also Komsky and Bowring Hanbury. So you can say, well, if Julian and Robert don't work out what's going to happen to the beneficiaries, has this testator said that something's going to happen instead? No. So this is not like Komsky. It's just like re Adams and Kensington Vestry. And so it doesn't, I would argue that there is no certainty of intention here. Now, in terms of the objects, is there certainty of objects? The potential beneficiaries are the employees of Smart & Co, lawyers and accountants. So are they certain? Yeah, because you'll know exactly who your employees are at any particular time. You'll be paying PAYE for them on, all sorts of things. So there's no problem. Now, there's an additional problem here. If this is a fixed trust for the employees, then the trustees should know how much each beneficiary is going to get. So you could also say there's a problem with beneficial entitlements, because how much of the 100,000 should go to each employee? So you could say this is like, this doesn't tell us how much each person is supposed to get, so that the trustee wouldn't know what to do. So I think, that if you look at that paragraph, that's mainly dealing with certainty of intention. But there is also this added problem if it's a fixed trust. Now then you have to say, if this is a trust that fails, what happens to the 100,000? So how this would be dealt with legally would be to say, this is a gift to Julian and Robert with a moral obligation. So here's a gift, Julian and Robert, of 100,000, but I hope you'll remember my employees. There's nothing to indicate here that Julian and Robert hold as trustees. So on that basis, you could say, if it fails, then it's a gift. If it said instead 100,000 to Julian and Robert as trustees, then they wouldn't be able to take absolutely, because then that's never been the intention of the testator to have, let them take. So you'd get probably what you'd get is a resulting trust. Is that all right? Yeah. Well, if you had a transfer of legal, well, I suppose what I'm saying is on death, legal title will go into the executor. If they're trustees, and it will probably go into the residue of the trust. Yeah. If it's a will, sorry. Yeah. If it was an inter vivos thing, you'd have a resulting trust solution.
Yeah. So this is either going to be a gift, in which it would go.
Well, if it's not clear they're taking as trustees, it would be treated as a gift with a moral obligation.
Yeah. If there's intention that, if it's a gift and it fails, if it's a trust and it fails.
If it's trust and it fails, those words would be treated as a gift.
It's a gift.
Plus a moral obligation. Yeah. But it won't be treated as a gift if in the deed it said to Julian and Robert as trustees.
As trustees.
Yeah, it wouldn't.
No. Right.
Yeah. Yeah. So they wouldn't get it in those situations.
Yeah.
But here there's nothing to indicate that they take anything other than. So in that sort of situation, it's saying, does that clause create a trust that they're to be the trustees, or is it a gift with a moral obligation? Yeah, that's tacked on. Okay, So if we have a look at the next one, 150,000 to be distributed by my trustees amongst such of my relatives, friends and acquaintances as they in their absolute discretion shall determine. So it doesn't look like there's any problem with certainty of intention here. It appears clear that this is going to be a trust. They've used the words trustee, distribution, so that indicates no problem there. If you're having a look at the trust assets, so the subject matter of the trust, that's clear, that's 150,000. So the problem here is with the objects. So now we know that this is a discretionary trust because we have the words as they, the trustees, in their absolute discretion shall determine. So we're looking at here at a discretionary trust. So the test that we use to determine certainty of objects in a discretionary trust is that any given postulant test, or the is not test, or the in and out test as it's called. Can it be said of any given individual whether they are a member of the group, of the class? So you have to go back to Macfarlane-Dalton giving you your test, the any given postulant test, and then you have to go to Rebaden and think about how you'd apply it. Now, there's an easy answer for the words relatives because Baden says it's certain. So you can say, no problem with the word relatives. Rebaden has said they're certain, though of course the three judges who gave the decision each came to slightly different interpretations of what the words meant. But then you have to look at, look at the words friends. Is that word, so if we look at Macfarlane-Dalton, we need conceptual certainty. So you say, well, is that a conceptually certain word? No, it isn't, because we all have different ideas of what a friend is. So again, you applied Baden, and then we've got the word acquaintances. So you say, is that conceptually certain? Well, it might be, mightn't it? You could argue that it was. You could say an acquaintance is anyone I've ever met, but it might fail anyway because it's administratively unworkable, it's too big. So it's all those issues that I'd be looking for you to discuss. And now the final question here, my residuary estate to my children, Oliver and Charlotte, subject to the provision from my estate of a substantial income for my secretary, Sylvia. So if you look at the subject matter, is this a trust or not? The subject matter is not a problem. My residuary estate, or my residue, has got a technical meaning, so that's certain. So we've got no problem with certainty of subject matter. So then we have to look at what is going on here. So what we have is words saying that the residue is to be given to Oliver and Charlotte, but in what capacity? Are they supposed to take it as trustees, and the terms of the trust would be provision from my residue of a substantial income for my secretary, Sylvia? Is that the terms of the trust? Or do they take it as a gift subject to a moral obligation, not legally enforceable, to think about Sylvia? So if we look at certainty of intention, really, it's actually not clear what's happening. All you've got really are the words subject to the provision. So it appears, that might be indicating that there's some sort of trust. But the real problem here is that if there is some sort of trust for Sylvia, we don't know what she's supposed to get. So the words provision from my residue of a substantial income, how are we supposed to know what that is? It's like Sprangian Barnard, and Palmer and Simmons, bulk of my estate. It doesn't sort of tell us exactly what Sylvia is supposed to get. Now, there is a funny old case. I didn't actually do it in class, but it's called Rigole. Just looking for a pen to write up the name of the word for you, but it's Golay. But it's one of those funny old cases. And in this case, a man who was married left certain assets to a woman, not his wife, her nickname was Tossie, and he left her the ability to live in a flat and certain jewels. And when he died, the wife challenged his will. And what he had also done, so he'd left his wife, this woman, Tossie, the ability to remain living in a flat, use these jewels, and he'd also said that she was entitled to a reasonable income from I think being a housekeeper or something of that sort. So after the guy died, the wife challenged the will and said that this, that this didn't create a valid trust instrument because it was uncertain for subject matter. You couldn't tell what a reasonable income was, and so the whole trust would fail. Probably Tossie was his mistress, and he was looking to look after her after he died. In fact, what the court did was looked at the term reasonable income, and they said actually, reasonable income is something that we can work out. If you look at what she's supposed to be doing, being a housekeeper, and we can go around and have a look at the going rates effectively, what the prices that would be paid to housekeepers at the time, and from that we can work out what a reasonable income would be. So they said that those words, reasonable, basically the word reasonable, gave them a yardstick to evaluate what she should get. So in those circumstances, that term was treated as being certain. Yeah. Is that okay?
See, you'd say, register to my children.
Yeah.
That would normally indicate a gift.
Yes. And then you've got this thing tacked on the end.
But then you've got subject to provision. So does that create a trust, or does that limit or reduce the size of the gift? Subject to provision from my residue.
Well, the idea with that, you'd say, is it a trust or is it just a moral obligation that's not legally enforceable? Is the way the courts have tended to look at those things?
Yeah, because you could say that Olivia and Charlotte are going to get the residue subject to some coming out first.
Yes.
Or it could be they get the residue subject to them using the residue to benefit Sylvia.
Yeah. Yes. No. That's right. Yeah.
Trust within that, as opposed to a limited gift.
Or. I mean, there's all sorts of things you can argue. You say, well, are they the trust? Is this a trust of which they are the trustees, and the beneficiaries are those two and the Sylvia? I mean, with all these things, there'll always be a number of ways you might argue them, depending on the words that you use, and any reasonable argument. If you want to create a different sort of argument, that's fine. The standard way with wills, we've looked at there's stacks and stacks of cases, but for your purposes, I'd expect you to have a look at Ree Adams, Kensington Vestry, and those cases that we've looked at, in class. That's all right.
So a summary of those cases. This often doesn't have a summary of the cases.
No.
You've got some summaries on the slides, haven't you?
Certain ones I have. I can always stick PDFs of them up online if you want them.
Yeah,
I'm happy to do that. Yep. Okay. Let me write myself a note. So I'll try and do it today when I go back. Yep. Okay. Should we roll on and have a look at the problem question? So this is actually an exam question. I can't remember where what it was an exam question for. Okay, so I'll give you a few minutes to read it, and just to start, what I want you to do is start working out the issues as we go through and what I might be looking to examine. Yep, that's it, yeah. Okay, should we start going through it? Okay, so normally when if you're looking at sort of a problem question like this, you'll be able to identify that there are certain transactions that you need to consider. So if we look at this, what we know is that we've got a situation here where David is attempting to give away his golf clubs. Then we have a situation where he's attempting to create a trust of a family farm. The third one is something we haven't really covered, but I'll go through with you just so you know about it. That's where somebody is trying to give away an interest, an equitable interest that they have. So you've got an interest under a trust, and how do you do that? And that's it. So we've got those three transactions. Yeah. Yeah, that's what we've got. Okay, so if we look at so you've got to look at, and deal with each separately. Okay? So first of all, we have this complicated, you'd never think that giving away something was so complicated. But here we have a situation where David is intended to make an outright gift to Miles. Okay? Now, if you have a look, when you get time, what you'll see is in the, what have I done with it? In the notes for the tutorial, what I have put attached to it, is that one? Yeah. You'll see you've got notes. There are various steps you take as you go through that will help you always come to the right solution with a transaction. So there are ways you do it. Ascertain the nature of the asset, ascertain the nature of the original owner's title, what method is being used to transfer, and you follow those questions through, and they'll bring you to the right answer. Okay? So it's attached to that document, to the actual problem. So you can read that at your leisure, but it just shows you, and stepwise you just go through everything like that, and it covers. So you're looking to cover constitution and formality issues, but also remember you've got to make sure if a trust is being created that the three certainties have got to be complied with. Okay, but those will give you your steps, and if you follow those through, you'll get the right answer. Okay, so here the first question is, if you look at it, would be what's the nature of the asset, because that affects how it's transferred. And here we've got golf clubs, which are a chosen possession, they're a chattel. Okay, so we know that they can be given away, and by deed of gift, but there's no deed here. So that means the other method at common law is intention to give plus delivery. Yeah? Okay, so you'd start off by saying something like David intended an outright gift to Miles. And you might mention that if you get time, that's method one in Milner and Lord, an outright gift. So what you're doing is a gratuitous transfer of the absolute ownership or the whole of the title you own to somebody else. So to do that, so you say that's what he's doing, and then you say, well, how you do it. So you say, he's got to transfer legal title in the golf clubs to Miles. And he's got to do that intending to make a gift. And that's that case recall. Now, transfer of title to chattels requires actual delivery, or sometimes you can have constructive delivery. So here, what's happened is, he said to Miles, you can have my golf clubs. And David says, I'll pick them up from my golf club next week and drop them off. Yeah, so you can say, well, is there intention to give? What he said is, you can have my golf clubs. So it looks like this is, doesn't it? It looks like this is probably an invalid gift, doesn't it? Yep. So what you'd need to do is explain why. Yeah, so you go into the case law of why this is an invalid gift. So what you'd say is that the law requires that the golf clubs, David should actually go to the golf clubs, pick them up or hand them over, or perhaps say to his son, they're in my locker, here's the key, get them when you want to. Or, something that would indicate that there is some sort of exchange of dominion. Now, there actually is not that I wouldn't examine you on this, but there is a fluke in this, or a trick in this sort of question that there's a very strange rule I'll just take you through in English law, which can trip people up, and it's called the rule in Strong and Bird. I mentioned it in the slides as an exception. There's this very strange exception that operates where if you are a potential recipient of a gift under a will, like Miles is, and the gift is incomplete, the gift can be completed if you are also made an executor of the will. So what happens, it's a really strange rule, what happens whatever else happens at the moment of our death, when we die, the legal title of our assets is sort of recognised as being, ownership of our assets will pass to the executor on the point of death. So under English law, where you have some sort of incomplete gift, and that's incomplete because there hasn't been constitution, legal title hasn't passed, if the executor gets, if the recipient of the gift is the executor, and they will then get legal title on death. So provided that if the donor intended to give the gift, and that intention didn't change until the moment they died, then English law can recognise that a valid gift has been made. It's just a quirk of English law. Yeah? It's called the rule in Strong and Bird. So in this situation, in this case, I wouldn't put it something in, to examine you on this. In this, if I was looking at that sort of problem, I'd say this is an invalid gift. But the mere fact that if Miles is the executor, then you could rely on this rule in Strong and Bird to say, well, actually, the gift has been perfected. At the moment of David's death, Miles actually got legal title to the assets, and provided David intended to make a gift, and that intention never changed till the point he died, then equity would treat the gift as valid. It's a funny little rule. Okay, is that all right? Let's have a look at the next section. That weekend, David took his grandson Ryan out for the day and asked Ryan if he would like to own the family farm when he's older. David then writes a note stating that the farm was to be held on trust for Ryan, and in the note he named Lucy as the trustee for the farm. David then telephoned his solicitor and instructed him to transfer the farm into Lucy's name as trustee. David's solicitor was away at a legal conference but assured David he would attend to the matter immediately on his return to the office in a week's time, and then David dies before the transfer has been made. Okay. So where would you start with this? The first thing you do is identify what he's intending to do. So you'd say, well, this is an attempted creation of a trust, and it's actually a transfer on trust, method 2 of Milroy. David is wanting somebody other than himself to be the trustee. In fact, it looks like the person he wants, well, his name says Lucy as being the person he wants to have a trustee. So in order to create a valid transfer on trust, you need to have a trust declaration that complies with the 3 certainties. So you need a valid declaration of trust, and then you need to transfer legal title in the land to the trustees. So we can have a look at the declaration and say, well, are the 3 certainties complied with? So you can say, well, how do we know what's going on? Well, look, he's written a note and he says that the farm's held on trust for Ryan, Lucy's the trustee. So you could say, well, there doesn't seem to be any problem with the 3 certainties here. The requirement from night and night to have 3 certainties is clear. It looks like there's certainty of intention because he says the farm is to be held on trust. It looks like there's certainty of subject matter because it's the farm and it'll be the property. And it looks like there's certainty of object because he's named the beneficiary, and that's Ryan. So no problem there. So we've got a declaration, but we know that we've got to have transfer of legal title to the land, and we also know that this is land. So as soon as you see anything with land, you should think about the fact that you need to fulfil formalities. Okay? So we'll deal with the formalities issue first because that's the quickest. So you basically would say, well, here, this is an attempt for the first time to create a trust of land. So section 25, subsection 2 of the Property Law Act requires that the trust must be created in writing and signed by the settlor. Now, what we have is a note stating that the farms is held on trust, or was held on trust for Ryan. Lucy's the trustee. That doesn't have to be a deed. All it says is that the trust has got to be created in writing. Yeah, so from that point of view, that note might suffice as writing. But what you don't know is whether the whole of the section's been fulfilled, because what it says is it's got to be in signed writing. So it's got to be signed by the settlor. And these facts, I don't think, tell you whether David has signed it. Now, where you get things like that in an exam question, you just do the alternative. You say, well, if it's signed, this would comply with formalities, arguably. If it's not signed, then it won't comply with formalities. And the section says a trust must be created in signed writing. So you'd have no trust. Yeah? Is that all right? Okay, so then we move on and we'd have a look at, what about the problem with constitution of the trust? Because what we know is that David instructed his solicitor to transfer title to the farm to Lucy as trustee, but David died before his solicitor could do it. Okay, so you go through the rules. To transfer legal title to land, the Land Transfer Act requires, well, either you've got two systems, haven't you? You've got a paper system or an electronic system. Where you're using your lawyer, you've got to use the electronic system. And basically there's been no electronic transfer. So legal title has not been transferred to Lucy as trustee, and the trust has not been properly constituted. So that means that the first position you take is Milroy and Lord. Now, Ryan is a volunteer. He hasn't provided any consideration. So equity will not assist a volunteer. Equity will not perfect an imperfect gift or an imperfect trust. And equity will not treat a failed transfer on trust as a self-declaration. David isn't self-declaring that he's going to be the trustee of this land. He's trying to make Lucy the trustee for Ryan. So you'd say the first step for equity is that equity won't help. And you could say, actually, this is just like Milroy itself. Because Milroy is a case where the trust failed because of the failure to transfer legal title to the shares to the trustee, Mr. Lord. So the next thing you'll do is say, well, is there any exception where there's a problem with constitution? So the first step is re-rose. Remember that we looked at that? And that says that if the settlor has done all in his power to make the transaction binding on him, done everything he could, equity will treat the gift as complete, even though legal title hasn't passed. Okay, so we've got to look at what happens here. And what we know is that David's telephoned his solicitor and told him to transfer the farm to Lucy in Lucy's name. In reality, what you do is sign an, isn't it an A&I form? You'd have to, but whatever's happened here, all David has done is instruct his own agent to do something. If he had signed the A&I form or whatever else you need and instructed Miles's lawyer to transfer, then maybe Rerose would work. But he hasn't done that. He's used his own lawyer. And that means that at any time up until the actual transfer takes place, well, he dies first, but he could change his mind. So that means Rerose doesn't work. So then you say, well, you look at Rerose, it doesn't work. So then you'd fall back on Pennington and Wayne. And you remember that equity, but in that case, equity said that it was, or the court said it was unconscionable to resile from the gift. So then you have to look at the facts and say, well, is there anything here that makes it unconscionable for this boy not to become a beneficiary of this property? Is this, what if the father had said to the grandson, I'll give you the farm, but died before it happened? I mean, that couldn't do anything about that if legal title, you know. And, yeah. So, so then you're looking at, well, is there something that makes this unconscionable? Is it unconscionable to disappoint a child? No, probably not. There's not much you could point to here. There's nothing that you could say, well, Ryan's relied on this. If I put in facts that said Ryan was delighted and immediately incurred a debt, you know, I don't know, to travel overseas to undertake a course, so there was some sort of, something that made it, you know, so he's dependent on this, you know, something that would make it unconscionable. Pennington Wayne might, you know, assist the situation. But the thing to note is that there is uncertainty as to when it's going to be considered to be unconscionable to resile from a gift. Yeah. Certainly there's nothing like the facts that there were in Pennington to point to, Pennington and Wayne. And I don't mind which way you argue it. So you could say, well, there are some similarities to Pennington. He instructed his agent. The agent assured him, you know, yes, I'll take care of it as soon as I get back. So nothing to indicate the lawyer wasn't going to do it. He'd informed his grandson, perhaps this was an important, you know, family asset that he wanted, you know, he'd passed on down some sort of family line. But there's nothing to indicate that Ryan has actually relied on it to his detriment. Yeah. Anyway, so you might be able to argue that there wasn't a problem with constitution, but with this problem at the end of the day, there's no trust because there's no formalities haven't been complied with. Is that all right? The third one, I can just take you through if you want, and I will just so you know. This is a situation in which you've got David. What the facts say is that David is a beneficiary under a family trust, so it shares in the family company, and he telephones his trustee and says transfer, what do you say, transfer the shares to? For Zach. So this is a situation in which what is occurring is that there's a transfer just of an equitable interest. So all that David owns there, it looks like this is a fixed trust. So all he has is an equitable interest. And he's looking to give away that interest to Zach. Now, there are some rules, just so you know, there are some formalities that can apply when you're giving away equitable interests, and that's under section 25, subsection 1 of the Act. But again, they only take effect when there's an interest in land. So the section 21 says, a disposition of any of the following must be in writing and signed by the person making the disposition. An existing equitable interest in land, so if the trust asset was land, David as the beneficiary under a fixed trust would have an equitable interest in land. Now, if that was the case, he would have to transfer his equitable interest in signed writing. Okay, that's fair. So the second thing is an existing equitable interest in a mixed fund consisting partly of land and partly of other property. So if the trust fund was land and those shares, David would have to do it in signed writing. But because the trust asset here are just these shares in this company, whatever it is, Marlborough Holdings Limited, You could say that it's not an equitable interest in land. It's an equitable, these are shares, they're choses in action, which are a type of personalty. So they're not caught by the rule of formalities. There's no need for signed writing. So David just simply saying to his trustee, don't hold for me anymore, hold for Zach, would be enough to transfer the equitable interest from David to Zach. So dispositions of purely of equitable interest and pure personalty are not covered by section 25, subsection 1.
Because it's not exactly clear that this could have been a discretionary trust. You don't also argue the other side as well.
Well, if it's a discretionary trust, then David doesn't own anything in equity. Yeah. And so there is an argument that interests in discretionary trusts are not alienable. You can't give them away or sell them. Yeah, there's some debate about that, but because you're not treated as owning anything, only having a spice or a hope, so you look at some textbooks and they'll say that it's inalienable. You can't give it away. But fixed trusts are different. Interests in fixed trusts, because then you do own something. You're treated as the owner of something in equity. Is that all right? Okay, so are there any questions? We've actually covered quite a lot today and we've galloped through it. Yeah.
Obviously, these types of questions, these aren't academic answers. You're looking for practitioner answers in terms of the examination. So we're not sort of large tracks. Just sort of answer the question, as you say, identify the weighting given by the marking.
Typically I would give, I'll probably do some, I don't know, I can't remember what I did last year. I'd give some short answer questions, which would just be, what is it, I might say something like, what is a contingent interest? Or, But normally I would give some sort of question that combined the three certainties, formalities and constitution. So what you need to answer that question, you've got to identify the issue, identify the relevant law. So we've got, apply that law to the issue that you've got and come to a conclusion. But I don't expect you to do a whole lot of research, because there's a lot of cases in equity. We've got hundreds of years of cases. You can rely on the materials that you've got in the manual, the chapter, and what we've gone through today. So but in terms of, what we do, we give you for your test is a take-home test that you can answer over a period of time. I think have we said 2 weeks? Yeah, I think we're deciding to make it a bit longer because people are in practice and working, and it's a week's too short, really. You never know what's going to happen. So I'm pretty sure we put that in the 2 weeks. 2 weeks to do it. Yeah. Oh, that's right. You do. You just have to use your judgment. But where you are doing a problem question, make sure you do that. Pick out the issue, identify the relevant law, apply it to the issue, and conclude. Yeah. If you've got any issues or questions that you want to ask, as you go through things, you can email me or phone me at AUT. So my email address. So the email address is helen.durvin@aut.ac.nz. We don't have direct lines. The phone number for AUT is that, and you get a very long message in a number of languages, and that's my extension, 5427. So you can either email me or leave a voice message, and I'll, if there's anything that you need discussed further. Yeah, so tomorrow you're coming in as well, and you'll have Simon Wheel from Anthony Harper, and he'll take you through a trust deed, sort of the anatomy of a trust deed, and his slides are already up as well. All right? So all of that, enjoyable weekend.
I must have an excuse to revisit equity.
Oh.